On August 16th, 2021, Justin Riddle and Aaron Riddle face a lawsuit from Charter West Bank in the Douglas County District Court over claims tied to the Anti-Cyber Squatting Consumer Protection Act and alleged trademark violations in a dispute that quickly drew serious attention and raised questions about intent and digital ownership. The case centered on a domain the couple created and used to publish a site called Corruption Report after tensions escalated during a mortgage conflict with the bank and its leadership. In May 2021, the couple secured the domain, while the disagreement was still unfolding, which the bank later argued showed a calculated move to gain leverage during the dispute. Court filings from the bank claimed the couple then offered to sell the domain back for $1 million, which the institution described as a ransom-style demand that crossed legal boundaries and intensified the conflict. Justin and Aaron chose to represent themselves in court and push their defense without outside legal counsel as the case moved forward under close review. The district court ultimately sided with the bank and issued a permanent injunction against the couple, reinforcing the bank position and limiting the use of the domain moving ahead. On March 29th, 2023, the couple escalated the fight by filing an appeal with the Nebraska Supreme Court seeking to challenge the earlier ruling and reopen the legal battle with higher stakes.
Very good. Then, Mr. Riddle, you may approach the podium and you may proceed.
Thank you, and thank you, Your Honors. May it please the court, Mr. Silver, members of the gallery. My name is Justin Riddle. This is my wife, Erin Riddle. We're here today as pro se litigants in this matter. Our lives, like anyone, were constantly evolving. After several years of hard work, saving, budgeting, and debt reduction, we were ready to purchase a home. We worked with Charter West, but at a point in the process, we were uncomfortable with their operation, decided to withdraw our loan and work with a different bank. In retaliation, Charter West put a code in the FHA system that indicated a non-existent child support obligation was past due. This prevented us from consummating our agreement with the new lender, as it's a system that every lender uses, but only the lender who put in the code could fix. After months of bootless requests asking Charter West Bank to correct the record, it was clear they were not going to remove the lie, so I proceeded to file a lawsuit. When it became obvious that we were not being treated fairly by the court, I decided my best course of action was to make a public gripe website. I researched the laws, and once I understood what was allowed, I alone, without the consent or knowledge of my wife, went to GoDaddy and searched for a suitable URL.
Mr. Riddle, just more for the benefit of the folks watching, the court to which you referred where you felt you were not being fairly treated, to what court were you referring to?
That would be the district court, the appeals court as well.
In the federal system.
Mm-hmm.
So not in the state court system?
Well,
the one you were talking about was the federal district court, and which then was appealed to the Eighth Circuit Court of Appeals.
Correct.
Now you may get around to something else, but I just want everyone to understand what you were talking about.
Thank you.
Your initial lawsuit was filed in the federal district court.
Yes.
All right. And there was motions to dismiss. The court dismissed certain parties. And did you appeal that to the Eighth Circuit?
I did.
Okay. And then you filed is there another action now in state court that we're here on today?
Yes. That's where I'm getting to.
All right. Very good. Thank you.
Incredibly, charterwestbank.com was available. I immediately purchased it and did additional research to verify I could legally use that URL. According to the Lanham Act and a very clearly defined fair use doctrine, because I'm not a competing business and my site is entirely set up to criticize, I am legally allowed. Charter West has decided to sue us for that website based on the Anti-Cyber Squatting Act, which brings us here today. Cyber squatting was the choice for the plaintiff, as it's the one and only way that someone can obtain a website by force. There's no other remedy in law that forces the transfer of internet real estate. However, Charter West has fallen short on their claim on every avenue, and I'll explain how.
Just to, again, be clear for the benefit of our audience, the Cyber Squatting Act to which you have referred is part of the Lanham Act, but there are other parts of the Lanham Act.
Certainly.
And when you were talking about having researched the Lanham Act, you were perhaps talking more broadly than just the Anti-Cyber Squatting Act?
The fair use doctrine was more broadly, but as far as the Lanham Act, I was very specific with cyber squatting.
That's, okay, that's what you're talking about.
Correct.
All right, thank you.
Thank you.
Let me just pursue that from a statutory standpoint. So this case is in the playground of the anti-squatting statute?
Mm-hmm.
Okay. And there are elements that would need to be proved by a party claim.
Precisely.
Okay. And generally speaking, what are those elements?
Well, to qualify for protection, one must either hold a trademark or be so well recognized on a national or global scale that their name would be sufficient for most individuals to know who they were. Charter West does not hold a trademark to my domain name, although if they did, the fair use is affirmative, and I've proven it several times.
When you say they don't hold a trademark to your domain.
Yeah, they're not
Well, I
trademarked.
just, hold it.
Oh,
So,
sorry.
To be precise, I mean, you don't trademark a domain name, you trademark a name.
Correct.
And your contention is they do not have a trademark for
Charter
Charter
West,
West Bank.
correct.
So the statute and the cases are referring to mark, not trademark in the.
Service mark, trademark,
Well, they're not fungible. So under the anti-squatting statute, the mark needs to be confusingly similar, right?
that would be one, that would be
That would be
one.
one of the elements, right? But it's not the same as trademark of likelihood of confusion. They're not the same. Do you agree?
I would agree, yes.
Thank you.
Thank you, Your Honor. Additionally, notwithstanding the rest of the world, most people in Nebraska don't know whether Charter West is an Oregon-based shipping company, California travel agency, or Nebraska bank, because they're not well-known and large, thus disqualifying them from the other prong.
There are two words used in the phrase to which I think you are referring, distinctive or famous. Are you talking about both of those words, or are you talking about just famous?
Famous.
What about distinctive?
It's not trademarked, so it doesn't have any, there's no protection for that.
When you say it's not trademarked, are you saying there's no evidence that they have a registered trademark?
Correct.
With the USPTO?
Would I be able to step to the next prong? I think it'll answer all the questions. Thank you.
Sure.
In case the lack of qualifying conditions does not on its own satisfy the court, there's a second, standalone, fundamentally more important area the claim fails. Public criticism, parody, gripe websites are constitutionally protected activities. When I purchased the site, I immediately started cataloging the way that Charter West had fabricated information to damage us, the little guy. It's easy to explain through a website. I'm going to skip some of this. But in order to win this case, Charter West must prove I was acting in bad faith. This is simply impossible to do based on the factual and legitimate gripe that initiated my complaint prior to purchasing the website.
It seemed that the district court, the state district court, was concerned about the offer to sell the website for $1 million. Does that have any impact?
I'll skip ahead to that. You will see an email string from the plaintiff titled "Settlement Offer Withdrawal" was allowed into evidence despite my objection because, as Judge Durr insisted, quote, "It's not an offer of settlement because there could be some more nefarious information contained," simply meaning that he would allow those emails with an open admission that he could use them as a fishing expedition. So let's just skip to because we're running low.
Before you move on, with regard to your bad faith argument, are you saying there could not be bad faith here because what you were asserting was true?
Correct. It's not only true, it's legal. And I haven't impersonated the bank. I haven't tried to sell bank products. Anything is for sale. If the bank wants to buy the website, I can sell it to them. That's not cyber squatting. I mean, it's defined, and I just haven't done that.
It's defined in that bad faith has 9 statutory factors of bad
Correct.
faith, right? 15 U.S.C. 1125, D1, B little 1. Did I do it? Okay, so, right?
And there are
they're
other
not
things that
exclusive.
can be considered as
Right,
well.
Right, and that is kind of a reference for analytical
Exactly.
purposes. Right, okay.
And then I would also like to mention, if there's any remaining doubt, all one needs to do is visit www.nissan.com. You'll see that it's currently owned as a gripe website, and that www.nissanusa.com is what the world's 9th largest car manufacturer and 157th largest company owns. I pray the court upholds the same decisions as every other high court regarding gripe websites and move them to dismiss with prejudice, as there's really no other legal question to answer. I would like to reserve my remaining time.
You may.
Thank you.
Thank you very much.
The record shows that Justin Riddle secured the domain after a clash over a denied FHA mortgage loan, which he claimed stemmed from a careless mix-up tied to a child support record, and that moment became the trigger for a wider legal fight. Under 15 U.S.C. 1125, the law blocks domains that look confusingly similar when there is a bad faith plan to profit, yet Riddle pointed to the safe harbor in 1125 D1 and argued his actions fit within its protection as a lawful use. He said the site worked as a non-commercial gripe platform under the First Amendment, where the name was used only to identify the subject of criticism, and nothing more, which he framed as nominative fair use that is allowed in public discourse. A central clash came from how Charter West Bank described the $1 million figure, because the bank painted it as a coercive demand, while the defense insisted it reflected a settlement value tied to a mortgage dispute rather than a price tag for the domain itself. When the case reached the Nebraska Supreme Court, the spotlight moved to trademark strength, and the key issue became whether the bank name held enough distinctiveness to qualify for protection at that time. Because the mark was not registered, the bank had to prove that Charter West had gained secondary meaning, and that the public linked the phrase to the specific institution, instead of seeing it as a broad regional label which set a higher bar for their claim and shaped the path of the appeal.
Mr. Silver, good morning to you.
Good morning, Mr. Chief Justice. Your Honors, my name is Jeffrey Silver. I have the privilege of representing Charter West Bank in this matter. This is not a freedom of speech case. This is an internet blackmail case. What this gentleman did was buy a website that he found that, unfortunately for Charter West, they did not have, and he bought this domain site, and he did it for one purpose only, and that was to injure and damage Charter West. The emails that are part of the record, I think, reflect astonishingly what his bad faith is, if I may.
May I jump ahead? And
Sure.
that is, I think you mentioned this injury to Charter West. What is the injury to Charter West on this record?
The injury to Charter West on the record is the confusion that it's going to cause with respect to its website that it has, that we have in the record.
Is that prospective, or is that already happened?
I'm sorry?
Is that prospective, or has that already happened?
That is, well, in one of his emails, and I'll reference it for you, Mr. Chief Justice, he says the damage is going to happen and we're not even going to know about it. So the fact of the matter is, there may be damage happening to us.
But then you're all speculating.
Well, you can't speculate about the damage because he's telling us in his email that the damage is going to occur and we're not even going to know that it's occurring.
Well, is this your proposition that some navigational miscue results in damage automatically?
No, it's not a navigational miscue. It's an intentional, purposeful attempt by Mr. Riddle to damage the bank by having his website, or this website, put up and make believe it's Charter West Bank.
But I think you answered it with the answer to, was there evidence of bad faith? And evidently you believe so, and we
Yes,
accept that's your position.
if I may.
But
What about all these cases that seem to say gripe websites are permitted? Do you disagree with those cases, or is this case distinguishable from those?
This is not a gripe site. I understand that gripe sites are okay. If somebody wants to make a gripe site about Charter West being really bad and not doing everything, that's fine. That's certainly protectable. This is not a case about a gripe site.
What distinguished this?
Because in his, if I may, in our exhibit number 3, he says in his email, by next Wednesday, I can absolutely annihilate your client. Please play your game. He does not indicate that he has a problem with Charter West or a problem with Charter West in terms of how it handled his loan, which was already decided by the district court, federal district court, and then held up on appeal by the Eighth Circuit. He's wanting to damage Charter West. It's different in my mind from saying a gripe site.
Hold on one second. Isn't that the case for everyone that wants to operate a gripe site? I mean, they're displeased with their experience with the company, and they want other people to know about it. What's problematic about that?
It's not problematic to have a gripe site, but if you look at the context of all the emails, first of all, he buys the domain name, then he wants to sell it, which is exactly what the Anti-Cybersecurity Act talks about.
It's the request for payment.
Yes, is different than just a gripe site. And interestingly enough,
Suppose he had registered IHateCharterWestBank.com. Would the Anti-Cyber-Squatting Act apply to that?
if you just had that domain name, the answer would be no. But that's not the case in this case. Not only does he have the domain name, but as part of the Cyber Squatting Act, he has to sell it or you have to want to do it for commercial purposes. The emails say he wants to sell it to us, he wants $1 million from us to buy that domain name. That is different than what Judge was talking about as a gripe site.
One of the assignments of error that your opponent did not particularly talk about this morning at any length was the argument regarding Rule 408 and his objection to the evidence on that ground.
Sure.
What's your take on that?
My take is 27408, and this court said in the McGill restoration case, that settlement discussions are immunized from being admitted into evidence. This was not a settlement discussion. This was a threat made by him in various emails that we have in the record to destroy Charter West. This is not a case where he said, I want X, in exchange for X, I'll give you Y, and we'll settle the case. These are threats. And if you look at 27408, it's a lot different. In 27408 talks about offered for another purpose. This was not offered for the purpose of demonstrating liability to us for the loan process, which has already been litigated. This was offered to demonstrate the threats that he was making against Charter West as a result of him being unhappy. And the fact of the matter is, going back to your point, Judge Papik, there are emails where he has other websites that he wanted to buy. He got WW Nebraska Corrupt Banks, WW Corrupt Nebraska Bank. He could have all those domain names, and under any one of those domain names, or if he wants to have his own domain name, he can have that, and he could say all the bad things he wants to say about Charter West, subject, of course, to perhaps
You
libel
pointed
lawsuits.
out emails, several times to support your argument here. Was there anything actually on the website that you're asserting is disallowable?
We did not see anything on the website that was offered in evidence. All we offered into evidence to support our position were the emails where he demonstrated, one, I want to sell the domain name back to you.
So to answer my question, there's nothing in the record that shows that there was anything on the website that was disallowable.
That's correct, Your Honor. We agree with that.
So the crux of the case is the offer to sell for $1 million.
I'm sorry?
That's the crux of the case, the $1 million offer or sale?
No, that's not, that's part of the case. Part of the case is also I want to annihilate you, and it's also part of the case where he wants to sell the domain name back to us. If you go back to the Anti-Cybersecurity Act, it talks about trying to sell it. So he bought this domain name, or I don't know how much he paid for it, we don't know that, but he has the domain name, and then he wants to sell it either to us, or if we don't buy it, he's going to sell it to somebody else.
If he'd offered a different number, less than $1 million, would that be a violation?
Yes, because
If he offered to sell it for what he bought it for, would that be a violation?
Yes, because if you're talking about, if you look at the act, it talks about selling it for a commercial purpose. And here, it doesn't matter if he was going to offer it to us for $1. He was selling it for a commercial purpose, which brings him squarely within the act. And that's why Judge Durr was correct in issuing the permanent
There
injunction.
still have to be bad faith, though,
So
wouldn't
you
there?
think that goes to the bad faith intent to profit from the use of the name as opposed to owning the name?
I think that goes as one component of it. I think the other component of it is, if you look at the threads through the various emails, when he says, I'm going to annihilate you, I'm going to damage you, talking about Charter West, in connection with the sale, it all puts together a purpose. This is not, as Judge Papik asked before, this is not a gripe site. You want to have a gripe site? Be our guest.
Before your time expires, I want to expand on your last thought there. In response to one of my earlier questions, I thought you agreed that a website like I Hate Charter West Bank would be perfectly legal.
If standing in and of itself,
Okay.
I don't know that we could stop that. But
Now, I want to talk about the scope of the injunction that was actually granted. And I think you can see where I'm heading with this. The scope of the injunction was not just using this website, but any other domain name containing the words Charter West.
yes.
Is that defensible?
I think it is defensible.
Why?
Because when Judge Durr, if you recall the sequence of how we got back to Judge Durr, we went back to him on a rehearing. And initially, he did not issue the injunction because he thought we had not demonstrated damages. But when he looked again at those emails, and he looked again at what the purpose of those emails were, and the fact that I think the most important part of the response to you, Your Honor, is he tells us, Mr. Riddle tells us in his emails, you will not know the damage that we are causing. So I think Judge Durr understood that because we're never going to be able to know the damage that's going on, he decided that it was the best thing to do was just to
Well,
stop.
take an easy case, damage like somebody is redirected, right, to the website that's, quote, squatting, right, and buys stuff there instead of where they really intended, right, to go to the authentic vendor. Now you know that's redirected business.
Yes,
Okay,
yes.
What's the injury again?
The injury is certainly,
Based on evidence.
the injury is that people that are going to want to do business with Charter West, and I think in the record demonstrates that Charter West has remote banking. So we have remote banking. Somebody is going to go to that remote banking and see his domain name before they're going to see Charter West's domain name and think,
But he's not selling mortgages.
certainly, I agree with that. But I don't think that frankly, Your Honor, I don't think that makes a difference that he's not selling mortgages.
Didn't the website actually say, we're not Charter West Bank, right in it?
He had that on as a disclaimer, but that's after the fact, Your Honor. You get to the website. If you're a customer of Charter West and you go to their website and you see his domain name, then you have to go through, well, we're not Charter West. How do you know we're not Charter West? I don't think that disclaimer takes.
Does Charter West have on its website, we're not Charter West?
We do.
You say that you're not yourself
No,
on the
we-
website?
Well, no.
Okay.
Is there evidence in the record that there's a mark that is famous or distinctive?
I would say, Your Honor, we acknowledge we do not have a trademark.
So what gives you protection under the act?
What gives us protection under the Act is the fact that we have a domain name, multiple domain names that have the name Charter West in them.
You concede that there's no evidence in the record of a famous or distinctive mark.
I would agree with that. We do not have that registered as a mark.
And I'm not asking about registered. I'm not asking about
and-
registered with the USPTO. I'm
And the
saying
rest of the answer was, we don't have anything that indicates that it's famous
distinctive. Is
or
there evidence
distinct.
that it's distinctive?
Or distinct.
Aren't
we do.
those requirements to proceed under the Cyber Squatting Act?
I don't think they are. I think if you look at the Act, it does not require you to have a trademark, or it does not require you to have a specific, distinctive, famous, or whatever adjective you want to add to the word.
Okay, let's say I open a store and I call my store Hamburgers because I sell hamburgers. And someone else then gets the domain name hamburgers.com. Can I bring a cyber squatting claim and say, I got a mark, my store's called Hamburgers?
No, because
What's different about this?
The difference is, not only did he get the name, but he wanted to sell it also. That's what the critical difference is. It's not just having the name. You can have Hamburgers, and I can go out and get and open up another store right next to you that says Hamburgers. But if I buy the domain name Hamburgers, and then I come to you and say, you know what, I have the domain name Hamburgers, but I'm going to sell it to you for X dollars so that you can take me out of the picture, then I think you're bringing yourself within the purview of the act, and then I think we have something to talk about.
Chief, can I ask one more question?
You may.
You had said this is not a gripe site. Why is it not a gripe site?
It's not a gripe site because a gripe site doesn't involve somebody wanting to sell it. What happens is,
The key difference is wanting to sell it.
yes, and not only wanting to sell it, but offering to sell it, not only to us, but indicating that if we did not buy it, he would sell it to somebody else or some other trust that would take him out of the picture. So I think that makes a critical difference between somebody having a gripe site. Like I said before, if he wanted to have Bank Nebraska's, pardon my French, suck and talk about Charter West, perfectly okay.
Attorney Jeffrey A. Silver, speaking for Charter West Bank, pushed to admit the $1 million domain offer into evidence and argued there's a clear line between a normal settlement discussion and a coercive threat under Nebraska Evidence Rule 2748, which became a key battleground in the hearing. He acknowledged that settlement talks are often protected, but relied on the other purpose exception backed by McGill Restoration to claim the demand showed an independent act of cyber extortion rather than a sincere effort to resolve the mortgage dispute. Silver argued that this conduct placed the Riddles outside the safe harbor of the Anti-Cyber Squatting Consumer Protection Act because the domain was tied to a clear commercial objective framed as a ransom demand, which he said revealed bad faith intent to profit. The court then turned its attention to a deeper problem in the bank case and examined whether the foundation of the claim could even stand before weighing intent or conduct. Because the bank did not hold a registered mark with the United States Patent and Trademark Office, it carried the burden to prove the name had distinctiveness or fame at the time of the domain registration, which is required to move forward. The justices noted the record lacked proof of secondary meaning for a geographically descriptive term and pointed out the absence of consumer surveys or long-term advertising data that could show the public uniquely linked the name to the bank. In the end, the court signaled a strict order of analysis and made clear that even if bad faith were assumed, an ACPA claim cannot succeed unless the plaintiff first proves a valid protectable interest in a mark. And without that base right, the motives of the Riddles hold no legal weight in the final outcome.
You 2 minutes, Mr. Riddle.
Thank you. One, I will just say that, and again, as far as the admissibility of those emails is in question, but blackmail is not cyber squatting. So if he wants to say I was trying to hold them hostage for this money, that's a separate charge that he knew wouldn't fit because we were in the process of a negotiation, which is why this settlement negotiation was in the title of the email from them. You know, this was started by Charter West. It was continued by the CFPB, the Department of Banking and Finance, the Fed Reserve of KC, the Attorney General, the Ombudsman, the lower court, and the appeals court in that order. Every single tax-funded agency and safeguard was either incapable of reading or conspired to harm a citizen, leaving only a perfectly documented exploitation by every party. In my original case, the material change was as easy as looking at one single checkbox on one page of one mutilated document, yet somehow 0 over 24 trained experts knew what spoliation is. In this case, it's without question Charter West is to silencing a critic. Everyone, including the lower court, states it. That's an admission, not a cause of action. While representing myself, I've watched as every single legal professional use their training to take advantage of what they mistakenly saw was a weak target. This complete disregard for the law made it impossible for an average citizen to navigate what should be an unbiased legal system. Both of my cases, I feel, have proven systematic abuse, making it clear to me that if you're not in the club, the law is not just discretionary, it's irrelevant. The system left me one option, a legally acquired gripe website. To affirm the decision of the lower court, there must be a question of law. If a question exists in any of your minds, it should be asked right now to stop this cycle of abuse, and after 7 years, finally give me one fair opportunity to respond to something that would call into question what I've said.
Mr. Riddle contends that the allegations of cyber squatting and blackmail represent a fundamental misapplication of the ACPA, which necessitates a bad faith intent to profit, an element he argues is absent in a non-commercial gripe site used for the exercise of First Amendment rights. He asserts that his communications with the bank characterized by the appellee as blackmail were protected settlement communications under Nebraska Evidence Rule 27-48. He maintains that an offer to cease public criticism in exchange for the rectification of an underlying grievance is a legitimate exercise of litigation privilege and an attempted compromise rather than an extortionate act. The crux of the appeal, however, centers on spoliation of evidence and a violation of procedural due process. Mr. Riddle asserts that a mutilated document constitutes fraud on the court by invoking the spoliation inference. He argues that the bank's failure to maintain the integrity of the original record must result in an adverse inference, a legal presumption that the unaltered evidence would have been unfavorable to the bank's position. Mr. Riddle characterizes the subsequent litigation as a weaponization of the legal process designed to silence a critic of foundational fraud. Finally, Mr. Riddle challenges the procedural equity of the proceedings, arguing that the endless resources of a financial institution create an insurmountable barrier for the average citizen. He invokes the Equal Protection Clause and the judicial mandate that pros pleadings be held to a less stringent standard than those drafted by counsel. He concludes that without appellate intervention to address the threshold issue of evidentiary integrity, the legal system risks functioning as a tool for corporate interests to suppress dissent rather than a forum for the impartial adjudication of facts. On May 19, 2023, the Nebraska Supreme Court issued a mandate reversing the district court's decision, effectively vacating the permanent injunction against Justin and Aaron Riddle. This appellate victory restored the Riddles' control over their domain and affirmed their right to maintain the corruption report without the threat of judicial censorship. The court's holding turned on a fundamental principle of trademark law, the requirement of a protectable interest. The ruling underscores that the ACPA cannot be weaponized to silence critics when the underlying entity lacks a legally cognizable trademark. In the end, Justin and Aaron Riddle kept their disputed domain name, containing the bank's name, as the court found no evidence of bad faith, intent to profit, or trademark infringement, upholding their right to use the site for consumer criticism. This case presents fundamental questions about trademark distinctiveness and consumer speech in the digital age. Mr. and Mrs. Riddle successfully challenged the banks, standing by asserting that Charter West Bank failed to meet the threshold requirement of protectability. Under the spectrum of distinctiveness, a mark that is merely geographically descriptive, like Charter West, is ineligible for protection under the ACPA unless the plaintiff can prove secondary meaning. Because the bank lacked a federal registration, it was denied the statutory presumption of validity. Consequently, the bank bore the full burden of persuasion to demonstrate by a preponderance of the evidence that the public uniquely associated the mark with their specific institution. The Nebraska Supreme Court's finding of a wholly deficient evidentiary record rendered the bank's claims of bad faith legally insufficient. This reversal underscores a rigorous judicial standard without a proven property interest in the mark. Even the most aggressive gripe site activity does not constitute an actionable violation of the ACPA. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.